Thank you for joining me this afternoon. I am going to deliver a fascinating webinar on the changes that we can anticipate ahead with the Divorce Dissolution and Separation Act 2020. As I'm sure you'll all be aware, the bill received Royal Assent on the 25th of June last year. It's billed as the biggest reform of divorce law in 50 years. And it is designed to reduce conflict between couples legally ending a marriage or civil partnership. It was going to come into force in the autumn of this year, but Chris Philp confirmed on the 7th of June that the government's indicative timetable of this autumn was somewhat ambitious, and the reforms will come into force on the common commencement date of the 6th of April next year. So plenty of time for you to get your head round the changes afoot, and should you so wish, to listen to this webinar again and again. The rules that I will present are those that we anticipate will come into force. They were produced for consultation by the Family Procedural Committee between December of last year and March of this, and they are currently being analysed. So these are the rules that went out to consultation. I'm not aware of the outcome of the consultation, and therefore whether there are going to be any changes to these draft rules. But as I say, this is what we anticipate. As you'll all be aware, being seasoned practitioners, that the aim behind this, this act was to reduce conflict within the legal process, particularly damaging for children. To promote individual autonomy, so that parties to a marriage decide whether or not it's come to an end, not the paternalistic state, and to reduce length, cost and hardship of divorce proceedings. So what I hope will become very clear is the move away effectively from needing to evidence the irretrievable breakdown. Currently, you'll be aware, an applicant, the petitioner, has to demonstrate one of 5 statutory facts: adultery, behaviour, desertion, and then the relevant period, whether it's 2 years with consent or 5 years and no consent. That's often framed as, of course, the concept of fault, which simply ups the ante from the very outset. And so there's a move away from this. There's a move away from the ability to contest, and it's simply a statement of irretrievable breakdown that will be lodged at court. So the key changes, and probably prompted by the case of Owens and Owens, which I'm sure many of you will recollect. All the way through to the Supreme Court, and poor Mrs. Owens in the end was unable to divorce Mr. So the key changes to applications for divorce and dissolution are, as I've already indicated, no longer providing any evidence of the conduct or separation facts, and it's very simply a statement of irretrievable breakdown without any explanation. No requirement to raise allegations, and as I understand it, it won't even be possible to do that moving forwards. The court will not look into whether or not irretrievable breakdown has been evidenced. It is simply going to be whether or not the statement requirement has been complied with. Again, as I've indicated, it removes the possibility of contesting the decision to divorce or dissolve the civil partnership. The statement itself is conclusive evidence of the irretrievable breakdown. There is still going to be a possibility of challenging proceedings, of course, for matters such as jurisdiction, so whether the court's got jurisdiction to entertain proceedings, the existence of the marriage or civil partnership, so whether there's a valid marriage, and for fraud or procedural compliance, which will include service. But other than that, no longer possible, as indeed for Mr. Owens, to contest a spouse's decision that this marriage has broken down. And there's an introduction of a new option to apply jointly. In addition, of course, to retaining the current ability of one spouse alone to initiate the process. That will allow, of course, cooperation from the very outset. So if there's a mutual agreement, both spouses can make a joint application. There is provision for a joint application to become a sole application. So if there's any concern from the outset that somebody might not play ball the whole way through, that shouldn't prevent a party from attempting at least to apply on a joint basis, at least at the beginning. And I'll come back to that in due course. There is a retention of the current two-stage process. So of course, the nisi currently moving to the absolute. It will now be conditional, moving to final. So that two-stage process. There's a new minimum time frame of 6 months, and that's dealt with in 2 stages. So a minimum 20-week period from the start of proceedings and confirmation to the court that a conditional divorce or divorce order should be made. And then a 6-week period between the making of the conditional order and the making of a final order. The idea really behind that is to try and balance the rights of both parties. In the absence of showing one of the 5 facts, it ensures that the decision to seek divorce or dissolution is considered one. I suspect many can imagine that, particularly with online applications now, a bust up one evening could quite easily lead to an application with a simple statement for a divorce. So that sort of builds in a period of reflection, and that's a 20-week period from the start of proceedings. So contacting the court effectively, not from the date of service. There is possibility for a statutory instrument to adjust the minimum time periods, providing that total period does not exceed 26 weeks. And there's also discretion to the court in a particular case to shorten the 26-week period, so as to make either the conditional or the final order, or both, earlier than the period specified in the statute. And of course, I'm sure many of you will have dealt with situations where that's been particularly important, if there's a signal for bankruptcy, or indeed if somebody is about to have a baby, etc. So there will be provision in there for the court to shorten that period. There's also special protection for respondents, effectively to delay the making of a final divorce or dissolution order pending resolution of finances. Many of you may recollect the case of Thacker, where Mrs. Thacker was effectively seeking a delay to the decree absolute. And whilst it was made in that particular case, it was delayed. The court made it very clear that that is very much the exception, not the rule. And so there is a bit of a shift with the new rules. Section 10 of the Matrimonial Causes Act has been amended by the Divorce Dissolution and Separation Act, so as to provide that there's special protection available to all respondents, which currently only applies in separation cases. Of course, it's only for respondents because one anticipates that joint applicants won't be seeking a final order until they're satisfied that they're ready and that finances are ready, if that is important. And if one becomes a sole respondent at any step along the way, this protection, of course, will become available, and it will be important to ensure that one has made a Section 10(2) application as soon as one understands that the application is proceeding as a sole application. And again, I'll touch upon this slightly further in due course. The rule prohibiting divorce or dissolution within 1 year of marriage or civil partnership is retained. Terminology is updated, making law more accessible and more consistent with that for civil partnership. So I suspect I've already touched on this, but petition for divorce becomes an application for a divorce order. Petitioner becomes applicant, decree nisi, conditional order, and decree absolute, a final order. There are relevant changes also in the application for separation orders, much the same, removing the fact requirement and replacing it with the statement of irretrievable breakdown, and again making provision for joint applications alongside sole applications. And there are some minor changes also being made in relation to proceedings for nullity, essentially amending the minimum time period before the conditional order can be made, again to bring it in line with what will apply for divorce and civil partnership. So as I've indicated, the changes in procedure are draft in essence, because the outcome of the consultation is still awaited. The most significant changes are made to parts 6 and 7 of the family procedure rules. Part 6 in relation to service, both within and outside the jurisdiction, and part 7 in relation to the procedure for applications, especially, of course, with the advent of the joint application. There are other changes, particularly definition of disputed cases, no longer defended, and listing of case management hearings in disputed cases. I'll come to look at those in a moment, and other bits and pieces, predominantly consequential changes within the FPR. Of course, where there's reference to petitioner, it will become applicant, and so on and so forth. The committee, the Rules Committee and the President of the Family Division will consider in due course whether new practice directions are needed, as well as existing amendments to the existing practice directions. So to try and sort of assist with the overall process, the overview looks like one will make an application, first of all, for divorce, judicial separation, dissolution, or a separation order, with a very simple statement of irretrievable breakdown and a statement of reconciliation, rather as we do now. That kicks off a 20-week period of reflection, and one may withdraw an application at any point before service. The application is then served on the respondent within 28 days. That 28-day period does not impact or interrupt the 20 weeks. And it's served with a form for acknowledging service and notice of proceedings. In the case of a joint application, the court must send a copy of the notice of proceedings to both parties. And then within 14 days of service, the respondent must file an acknowledgement of service, which he must sign, or his legal representative, and that will include his address for service and an indication as to whether or not he or she intends to dispute the proceedings. Where it's a joint application, again within those 14 days of service, any joint applicant must acknowledge receipt of the notice of proceedings. For a respondent who intends to dispute the proceedings, he or she must file and serve an answer within 21 days of the date on which the acknowledgement of service is required to be filed. If there's simply a dispute about costs, no answer is required in relation to that. It's possible to amend an application at any time before an application for conditional order is made. For example, one may start off with a sole application and decide to pursue it on a joint basis. Following that, the application, one will make an application to court for the consideration of making a conditional order. That will be accompanied with a statement stating whether or not there are any changes in the information that was provided on the application, and confirming the truth of that, and where an acknowledgement of service has been signed by one party, a confirmation of that party's signature. For nullity, judicial separation or separation, this can happen, so the application for the conditional order, at any time after the filing of the acknowledgement of, at any time after the expiry of the time for the filing of the acknowledgement of service, provided that no party has filed an acknowledgement of service indicating an intention to dispute the proceedings. And in any other case, at any time after the time for filing an answer has expired. For divorce or dissolution, it's any time after the end of the 20-week period. And of course, as I've already indicated, that's 20 weeks from the date on which the application was issued, providing, and again, the points as above, the time for the filing of the acknowledgement of service has expired and nobody has indicated an intention to dispute the proceedings. And in any other case, time for the filing of an answer has expired. The application for this conditional order can be made in the case of a joint application by one party or both, or by a single applicant, and it must be served on the other party. If the court is satisfied that an applicant is entitled to the conditional order, the court must so certify and direct that the application is listed before a judge for the making of an order at the next available date. If the court's not satisfied, then directions will be given as to what steps are needed to be taken, or the case would be listed for a case management hearing. If costs are sought, the court will either certify that the applicant is entitled, if the court's so satisfied, or if not, make no direction about costs. Unless Rule 720 applies, which is essentially the intervention of the Queen's proctor, and none of that's really changed. It's as it stands in the rules currently. Conditional orders will be made final by giving notice of a wish to make the conditional order final by any party in favour of whom the conditional order is made, jointly by both parties in whose favour a conditional order is made, or an applicant who's the joint recipient of a conditional order, providing that applicant has given 14 days notice to the other applicant, and that applicant has to file a certificate of service of that notice. And that really is to give protection if proceedings have been joint to that point, that the joint applicant who is no longer part of this process for the final order knows that it's sought and can make that 10-2 application to delay effectively pending resolution of finances. It's only 14 days notice, so that really does need to be borne in the forefront of minds. And the draft rules provide that the court will make the conditional order final if satisfied that no application to prevent the conditional order being made final is pending, and that the provisions of section 10.2 don't apply or have been complied with. And just a note, if notice for this making of the final order is 12 months after the making of the conditional order, rather as now, it must be accompanied by an explanation in writing stating why the application hasn't been made earlier. So picking up on some of the particular changes to the family procedure rules, I'll deal with part 6 in relation to service first. I have notes that I've drafted and which can be made available, and this is set out in detail in those notes, which I'm, as I say, very happy to pass on. Please do get in touch with Chambers. Alternatively, actually, forgive me, I was about to say there may be a link. Please get in touch with Chambers or email me directly and I can send on these notes. In short, the main substantive draft changes that are made to Part 6 are in relation to who is to serve, the method of service, and time limits on steps to be taken. The who is to serve is a new rule 6.5, and it's the court will by default serve applications in the first instance, as opposed, of course, to the current position where the applicant serves by default. The idea behind that, of course, is to ensure swift service on the respondent, particularly in the context of online application. It is, however, still open for an applicant to elect to serve. The method, main change here, and this is Rule 6.4 and 6.7a, is the court can, an applicant can serve henceforth by email. But it's not quite as simple as that, because one needs to send notice of the email by post, confirming that such service has taken place. So there then needs to be this postal notice. So you won't be able to serve simply by email if you don't have a postal address for a respondent. You'll need to make an application for alternative service in the usual way, because of course you won't be able to send the postal notice, or the court won't be able to send the postal notice. Time period in which steps must be taken to serve. This applies to service within the jurisdiction and for service in Northern Ireland and Scotland. It's by 12 midnight on the calendar day, 28 days after the date of issue of the application, of whatever the step is. And so, of course, for email, that is sending the application by email and sending the notice by post. There are other bits and pieces in terms of the changes. For example, an applicant can apply for an extension of the 28-day period, much like current applications to extend timeframes within the rules. It will need to be an application made, supported by evidence, setting out steps taken, etc., efforts made to comply, whether one has acted promptly, etc. If an applicant's taken the relevant step, but doesn't receive an acknowledgement of service from the respondent, they need to apply for alternative service or deemed service to dispense with service in the usual way. And the time limit for a respondent to file an acknowledgement is 14 days from the date of service. Service outside the jurisdiction, but not Northern Ireland or Scotland, this includes Europe, is 12 midnight again on the calendar day, 28 days after the date of issue. The methods remain unchanged by the revised rules. So effectively Rule 6.45, 6.46 remain unaltered. Insofar as Part 7 is concerned, Part 7 has been restructured, but not particularly rewritten. It's divided into 7 chapters. The main aim really is to provide greater clarity in respect of which rules apply generally, which have more limited application, specifically, for example, in relation to standard proceedings, i.e. what's currently undefended, and in relation to disputed proceedings. Costs in respect of matrimonial and civil partnership order applications. I've been asked whether or not there are any changes to either the fees or so court fee costs and or the rules. Court fee costs currently the £550. There has been some mention of an increase to about £590, but no confirmation of that at this stage. The Law Society proposed that the court fee cost be reduced, which of course makes perfect sense, reflecting effectively the lower administration required of the court as a result of the online system, And of course, the fact that it really is a notification process as opposed to requiring the court to satisfy itself of this irretrievable breakdown. There's no sign of a decrease, so we can watch this space and hope, but I suspect it's unlikely. Insofar as the rules on costs are concerned, they have not been amended, and there are no substantive changes to those. The committee did consider that, and the extent to which current orders for costs are predicated on the 5 facts. Of course, with the abolition of those facts, should there be a general no order as to costs, with exceptions, and if no rule changes are made, would it be unlikely that cost orders are made in any event? In essence, what the committee determined was that it's too early to make changes, and further consultation may be needed once the rules are up and running and one sees the impact of those rules. So as things stand, there are no changes to cost rules. Difficult to see how a court will determine costs, but until we can see what the statement of irretrievable breakdown looks like, it's difficult to say. I've already indicated what currently are defended cases become disputed in the new rules, and it's limited to disputing the validity or subsistence of the marriage or civil partnership, the jurisdiction of the court to entertain the proceedings, and perhaps quite importantly, effectively what would now be cross petitions. So if a respondent has filed an application within proceedings that are live, that becomes a disputed case. Watch this space. So be very careful in those circumstances. It would be, of course, preferable to make a sole application a joint application. Indeed, that was a suggestion by the Law Society, given that a joint application can be converted into a sole application, but there is no such provision as things stand. And I think that really is because there is a real push towards a joint application, less conflict and greater collaboration from the very outset. So whilst one can make a joint application sole in due course, one cannot make a sole application joint, and one cannot cross-apply without ending up in disputed proceedings. The disputed will, of course, include procedural issues, fraud, for example, procedural compliance, etc. Standard cases essentially are what we would currently call undefended, and there's a shift, of course, therefore, in emphasis and ethos. Standard case reflects more accurately the reality of the situation. The vast majority of proceedings will be standard or undefended, with only very few disputed cases given the limited grounds. And then, of course, with the advent of the joint application and a real policy intention to encourage those joint applications, there's a focus on trying to avoid any unnecessary complexities that might undermine or discourage joint applications, but also to put in place some safeguards as a result of that joint approach. And so protection against fraud, and that's where if there's a sole application and a respondent is, if there's a joint application which becomes sole at some stage further down the line, there needs to be notice on the joint applicant, so that, of course, they are aware and can take the relevant steps. Notice of proceedings needs to be served on joint applicants, and they need to acknowledge the receipt of the notice of proceedings. Again, that mitigates the risk of a fraudulent joint application. There's also a safeguard in respect of sole applications for a final order when parties have made the joint application for the conditional order. That gives, of course, 14 days, as I've already indicated, 14 days notice. Party applying for the final order or to make the conditional order final needs to file and serve a certificate of service with the notice. And that, of course, gives notice to the person on the receiving end and allows them to make any application under Section 10.2 of the Matrimonial Causes Act. Case management hearings in disputed cases. So the new Rule 7.14 will provide that where a respondent files an answer and obtains permission, or forgive me, files an answer under the new rules or obtains permission to file an application under the new Rule 7.12, or indeed files an application for a matrimonial or civil partnership order, or under the new Rule 7.24, effectively the cross petition, a case must be listed for a case management hearing. That contrasts with the current provision at Rule 7.20, subsection 4. At the current time, the rules provide for the listing at the point of application for decree nisi, whereas this will be effectively upon the filing of the answer. So much earlier in the rules, in fact, it would appear that the standard process and procedure for HMCTS is, in any event, to do it much sooner. So really, it just brings the rules in line with what courts tend to do in any event. But again, it's geared to avoiding unnecessary delay within the process. Those are, in essence, the main changes that look set to come through the amendments to the family procedure rules. As I say, it's draft at present. We are awaiting confirmation as to the outcome of the consultation. And so I shall update this webinar in due course as soon as we have greater clarity. But for now, that's what looks set to come into force on or about the 6th of April of 2022. Thank you so much for your time and for listening. Please do feel free to make contact with me if you have any questions and if I might provide any help. Thank you.